I now call up my amendment number 5059.
Without objection, the pending amendment is set aside. Clerk will report the amendment.
The senator from Pennsylvania, Mr. Specter, proposes an amendment number 50.
Mr. President, I ask consent that further reading of the amendment be terminated.
Without objection.
Mr. President, I believe that history will look back at the period of time between 9/11 and the present as the greatest expansion of executive authority in the history of this country. We have seen the unauthorized military commissions. We've seen the extraordinary rendition to the frequent invocation of state secrets, privilege, and the misuse of so-called signing statements. The signing statements represent a fundamental failure of the Congress to utilize its constitutional authority when the Constitution provides that there is a presentment by both houses. The President either signs it or vetoes it. And the widespread practice has now come into play where the President signs and issues a signing statement undercutting key provisions of the legislation. I introduced a bill to give Congress standing to challenge that in court. It's gone nowhere because of the impossibility of overriding a veto and because of the considerations of case and controversy. We have seen in the context of the evolving issues the total ineffectiveness of Congress to provide the oversight of the intelligence committees. The National Security Act of 1947 expressly provides that matters like the terrorist surveillance program should be submitted to the intelligence committees. But that has not been done. Only a portion of the intelligence committees have been briefed. We have seen most of the limited briefing that was done only when the administration needed some support for the confirmation of General Hayden as CIA director. We have seen the provisions of the Foreign Intelligence Surveillance Act of 1978 bypassed by the executive branch on a claim of constitutional authority under Article 2, power as commander-in-chief, contrasted with the congressional authority under Article 1. A Detroit federal court declared the terrorist surveillance program unconstitutional. The Court of Appeals for the Sixth Circuit reversed in a 2-1 decision, with the dissenter reversed on the ground of lack of standing, with the dissenter filing an opinion showing ample basis for standing. The Supreme Court of the United States refused to review the case, called it a denial of certiorari. And that is the major constitutional confrontation of our era between the President asserting Article 2 powers as Commander-in-Chief and the explicit statutory provision enacted by Congress in 1978 providing for the exclusive means of having wiretapping. Instead, we have warrantless wiretapping. Now, the legislation pending now would provide retroactive immunity. And it provides retroactive immunity in a context that we could both preserve the electronic surveillance and leave the court with jurisdiction in one of two ways. One, by substituting the federal government as the party defendant for the telephone companies in the shoes of the telephone companies with no more, no less rights. Or secondly, requiring, as my amendment does, that the federal district court would decide constitutionality. No one is denying that the telephone companies have been good citizens. The argument has been made, well, there may be money damages, or there's a matter of public image which is involved. Well, monetary damages and public image, in my judgment, don't measure up to the right of privacy. Justice Oliver Wendell Holmes, in a case almost a century ago, said that wiretapping was, quote, dirty business, unquote. And it remains dirty business. It may be necessary on national security grounds, but it has to be done within the confines of the law. And that can be decided only by the courts, especially in the atmosphere that we have where the Congress has been so ineffective and where the Supreme Court of the United States ducked the issue on the case coming out of the Sixth Circuit, where there was ample grounds for finding standing to proceed with that case. Within the past 6 days, there's been a major development on this issue, on a judgment handed down by Chief Judge Vaughn Walker of the United States District Court in San Francisco. Judge Walker is the same judge who has the telephone company cases, which were consolidated and sent to him under federal rules on a multi-district panel. Judge Walker found flatly that the president exceeded his constitutional authority when he ignored the Foreign Intelligence Surveillance Act. This is the exact language in this 59-page opinion, quote, Congress appears clearly to have intended to and did establish the exclusive means for foreign intelligence surveillance activities to be conducted. Whatever power the executive may otherwise have had in this regard, FISA, the Foreign Intelligence Surveillance Act, limits the power of the executive branch to conduct such activities, close quote. So now we have the judge who is hearing these telephone cases having said that such surveillance is unconstitutional. FISA covers not only the traditional wiretaps, but explicitly covers, quote, pen registers and track and trace devices, close quote, which would include whatever it is the telephone companies were doing. But on that subject, we really do not know the full extent of what the telephone companies are doing. All we have are the allegations in the legal papers. And here, Congress is being asked to pass upon a program which most members have not been briefed on. As stated earlier on the floor today, 70 members of the United States Senate will be called upon to vote on the program, but they don't even know what it is. The House leadership has pointed out that most of the members of the House of Representatives have not been briefed. And in exchange with the senator from Missouri today, I raised the fundamental constitutional point that members' constitutional responsibilities cannot be delegated. Can't delegate them to a minority of the Senate. But that's what we're being asked to do here. It's a pig in a poke. The old expression describes it very well. We don't even know what the program is, and we're being asked to ratify it. The issue was put to the senator from Missouri, the chief defender of this bill, of any precedent where you have a case pending before Judge Walker, extended opinion in July of 2006 on appeal to the Court of Appeals for the Ninth Circuit. And if this act is passed, it will be unceremoniously jerked out from under the court, asking if there's any case in history, and I would repeat that challenge to the distinguished chairman of the committee. What we have left is really judicial review. And without judicial review, there is no way to effectuate the constitutional doctrine of separation of powers, which is so fundamental in our society. Even when the proponents of the bill talk about money and business reputation, no one is challenging the good citizenship of the telephone companies, and the likelihood of monetary damages is extremely remote. But if the government were to be substituted as the party defendant, that's a matter of dollars and cents, which hardly comports to the fundamental issues which are involved in civil liberties. It is understandable that Congress continues to support law enforcement powers because of the continuing terrorist threat. No one wants to be blamed for another 9/11. My own briefings on the telephone company's cooperation with the government have convinced me of the program's value, so that I voted for it even though my amendment to substitute the government for the telephone companies was defeated in the Senate's February vote. Similarly, I'm prepared to support it again as a last resort, even if it cannot be improved by providing for judicial review, the pending amendment. However, since Congress has been so ineffective in providing a check and balance, I will fight hard, and am fighting hard, to secure passage of this amendment to keep the courts open. Really, our last refuge, really our last ditch stand here. When the stakes are high, and they invariably are when Congress addresses civil liberties and national security, members frequently must choose between the issues of two imperfect options. Unfortunately, we too often back ourselves into these corners by deferring legislation until there is a looming deadline. Perhaps that is why so many of my colleagues have resigned themselves to accepting the current bill without seeking to improve it further. Although I'm prepared to stomach this bill if I must, I'm not yet ready to concede that the debate is over. Contrary to the conventional wisdom, I do not believe it is too late to make this bill better. Perhaps the 4th of July holiday will inspire the Senate to exercise its independence from the executive branch now that we are back in Washington. How much time do I have remaining, Madam President?
32 minutes remaining.
I reserve the balance of my time.